The accused, Peter Ndishu Njuguna, is charged with 2 counts. That is, firstly, of receiving a bribe, and secondly, of agreeing to receive a bribe, contrary to Section 61A, as well as Section 1812 of the Bribery Act number 47 of 2016 of January 2019, within Babadogo area, Nairobi City County, within the Republic of Kenya, being a person employed by a public body, to it, the Nairobi City Water and Sewerage Company, requested for a financial advantage of Kenya shillings $500,000 from Anthony Waweru Kinyanji, with intent that in consequence you would forbear charging him for an illegal water connection at said Babadogo area. In the second count, the particulars are that on 4th day of January 2019, within Babadogo area, Nairobi City County, within the Republic of Kenya, being a person employed by a public body, to which Nairobi City Water and Sewerage Company agreed to receive a financial advantage of Kenya shillings 300,000 from Nicholas Kinyanjui Ndwati, with intent that in consequence you would forbear charging him for an illegal water connection at the said Babadogo area. Any witness? In terms of the prosecution case, it was the case that the accused person not only requested for a financial advantage of Kenya shillings $500,000, but also agreed to receive Kenya shillings 300,000 as bribes from 2 complainants herein, in order to forbear charging them for an illegal water connection at Babadogo area. PW1 Nicholas Kinyanjui testified as the complainant in respect of count number 2. He said that on 3rd January 2019 at 2 p.m., he was in Gatundu when he received a call from his son, namely 2 officers from Nairobi City Council Water and Sewerage Department, had in Babadogo Riverside Estate, and alleged that he had done some illegal water connections into his aforesaid premises. Accordingly, the said officers demanded for $500,000 as bribe from his said son in order not to prefer any charges against him, and which sum was further negotiated and settled downwards at Kenya shillings 300,000. All these were purely based on what PW2 had told him, having admitted that he never talked to these 2 officers personally on phone. However, upon being convinced that these officers merely wanted bribes, since he had not done such illegal water connections at his aforesaid premises, he proceeded to the EACC, that is on 4th January 2019, when he lodged a report over this matter. And that was also the same day the aforesaid officers had demanded to be paid the said bribe. Consequently, he was not only assigned some officers, but also furnished with some treated monies, totaling to Kenya shillings 100,000, while stashed inside an envelope in terms of copy of the same, which were produced exhibit number 1, together with an audio and video recorder as evidenced by the inventory marked exhibit P2 and P3 respectively. Thereafter, they took off for their said premises, within the aim of handing over these treated monies to their aforesaid 2 officers from Nairobi City Water and Sewerage Department. Upon arrival, and after about 30 minutes, PW2 led the accused person to his office, who in turn introduced himself to him as an officer from the said department. The accused further told him about the said alleged illegal water connections from his premises, and consequently demanded for Kenya shillings 300,000 in order to drop any charges against him. But instead, he just attempted to renegotiate the said sum further to Kenya shillings 100, which prompted the accused to leave, having stuck to the former amount of Kenya shillings 300,000. They agreed to meet later the same day, but at different venue in Lakisama, in an open field. And upon arrival at this second venue, they waited for the accused, but in vain, only to be informed by one of the investigators herein, Mr. Nyakundi, that the accused, together with his other colleague, had spotted them and ran away. Thereafter, they proceeded to his place of work at Kariobangi and further lodged a report over this matter with his boss, who confirmed to them that the accused person was indeed one of their employees, but with no authority of disconnecting water supply to their customers. The following day, The accused, while in company of AP administration police officers, went back to his said premises and caused the arrest of his caretaker for an alleged water connection at his said premises, which they termed as theft. PW2, Anthony Waweru Kinyanjui, testified as the son of PW1 and as the complainant in respect of count 1. As expected, he just gave similar version of evidence as that given by PW1 here and above, and I shall therefore not repeat. However, his point of departure was in regard to his contention that he is actually the one who directly dealt with the accused person over the aforesaid alleged illegal water connection at PW1's premises. He likewise confirmed that he is the one whom the accused demanded Kenya shillings $500,000 from as a bribe, and which he negotiated downwards to Kenya shillings 300,000 in order not to prefer any charges of theft of the said water against PW1. Further, he confirmed that he is the one who called the accused and arranged for a meeting between him and PW1 on 4th January 2019 with full knowledge and directions of the investigating officers from EACC. PW3, John Otieno Nyagara, on his part, simply confirmed having treated the said Kenya shillings 100,000, which were in the denomination of Kenya shillings 1,000, as operation money, with the APQ powder on 4th January 2019, and thereafter stored them inside a brown khaki envelope marked Exhibit P5. He also confirmed having photocopied the said money in terms of Exhibit number 1, and equally prepared an inventory of the same in terms of Exhibit number 2. PW4 Anthony Gitai Bunjiri testified as an employee of Nairobi Water and Sewerage Company, that is zonal officer. He also confirmed that at the time of this incident, he was duly deployed at Kariobangi offices, wherein he was in charge of 2 supervisors and 9 water meter readers, including the accused before the dock. His evidence, in a nutshell, was a mere confirmation that the accused person was indeed one of their hard-working employees, that is, as a water meter reader, and that when Mr. Nyakundi informed me about all these corruption allegations leveled against him, he just referred this matter to their in-charge, namely Peter Atugora. At the same time, he confirmed having properly identified the accused voice and image from the video clip marked Exhibit number 5, as further fortified by the certificate accompanying the same marked Exhibit number P7. PW5, Joseph Leleruk testified as a liaison officer from Safaricom Company. He confirmed having duly complied with the court order marked Exhibit P9C by extracting the call data records from the SIM card number 0726 324134, which is registered in the name of PW2. He likewise provided the said records with a certificate accompanying the same as Exhibit number P10 and P11 respectively. PW6, after being introduced to him by PW2, when he explained to him what had transpired the previous day and all the charges as disclosed in the said disconnection order, and in the process of doing so, he maintained that PW1 attempted to bribe him with Kenya shillings 100,000, which was starched inside an envelope, which he declined together with his request to tear the aforesaid disconnection order. Thereafter, he left the said premises without demanding a sum of Kenya shillings 300,000 from PW1 as a bribe. To this end, he relied on the video clips and transcription produced by the process to further fortify his aforesaid contentions. At the same time, he categorically refuted having sought for any financial gain amounting to $500,000 from PW2 on 3rd January 2019 over the said illegal water connection. Accordingly, he vehemently denied ever committing all these offenses as preferred against him. Those were the evidence tendered by both the prosecution witness and the accused person. I've carefully reviewed the same. I've also given due consideration to the final written submissions dated 15th July 2022 and 26 July 2026 furnished to this court by the prosecution and the defense counsel respectively. By and large, both the counsels herein simply reiterated the above evidence by their respective parties in the said submission, save for the certain provisions and case laws I was referred to therein. The second, therefore, I shall not reiterate the same. I have now to decide whether or not the process proved to the required degree, that is, beyond any reasonable doubts, all the 2 counts as preferred against the accused person herein. I will consider both the counts together. As I have seen before, in these two counts, the accused is charged with the offense of receiving and or agreeing to receive a bribe, contrary to Section 61A, as well as Section 18(1)(2) of the Bribery Act. The only difference in the manner in which the particulars of these two counts were framed, the only difference is in the manner in which the particulars of these two counts were framed. That is, the amount involved, the complainants involved, and the date in which these offenses were expressed to have been committed. In the first count, it is stated that the accused person requested for a financial advantage of $500,000, while in the second count, it is stated that he agreed to receive a financial advantage of Kenya shillings 300,000 on 3rd January and 4th January from PW2 and PW1 respectively. And these amounts were actually meant to forbear both PW1 and PW2 from being charged with an offense of illegal water connection in the former's premises situated at Babadogo Riverside Estate. It was therefore incumbent upon the prosecution to prove to the required degree the two main ingredients and or elements of this offense as framed, and which according to me were, firstly, that the accused person had actually requested and or agreed to receive the aforesaid stated sums from the complainants as bribe, and secondly, that the said bribes were indeed intended to forbear the two complainants herein from being charged with an offense of illegal water connection. 6 subsection 1 of the Bribery Act, which stipulates as follows, and I quote, a person commits the offense of receiving a bribe if A, the person requests, agrees to receive, or receives a financial or other advantage intending that, in consequence, a relevant function or activity should be performed improperly, whether by that person receiving the bribe or by another person. B, the recipient of the bribe request for agrees to receive or accept a financial or other advantage, and the request, agreement, or acceptance itself constitutes the improper performance of the recipient of a bribe of a relevant function or activity. I've also quoted the entire section 6(1) and section 6 subsection 1 and subsection 2. In the foregoing premises, guided by the above provisions of section 6(1)(a) of the Bribery Act, as well as the particular of this count as framed, the prosecutor was only duty bound to prove to the required degree either of the two ingredients of these two offenses as disclosed therein, that is, request and or agreement to receive the sum of money in issued by the accused. I start by asking myself as to what sort of evidence was therefore tendered by the prosecution in proof of the above ingredients. PW1, who tells us the complaint in hospital count number 2, stated that it was his son, PW2, who informed him on 3rd January 2019 about the presence of the accused persons and one of his accomplices at his aforesaid premises, and who demanded $500,000 from him in order not to prefer any charges from him for an alleged illegal water connection. It was further he said that the two even went further and negotiated the said sum downwards to 300,000, and which amount was to be paid on 4th January 2019 at 10 a.m. However, having been satisfied that he had not committed any offense of illegal water connection at his said premises, and being aware that the said officer merely wanted the said stated sum as bribe, he decided to report this matter at EACC, and that's when he was given some treated money amounting to 200,000, together with the audio and video recording devices, so that he could use the same while talking and handing over this cash money to the accused. But in the course of their said meeting and conversation, the accused declined to receive the said sum on account that it was less. He, the accused, likewise maintained that he had a large team dealing with the said issue, and all of whom had a share in the said agreed sum of 300,000. Accordingly, just requested him to leave as he searched for the balance. It is worth noting that PW1 confirmed that during his aforesaid meeting and conversation with the accused person, as he tried to persuade him to receive the stated sum 100,000 instead of 300,000, both the audio and video recording devices which he had been furnished with by the ES officers were on. Furthermore, and as I stated here before, PW1's above evidence was mutually corroborated by PW2, almost verbatim, having maintained that he was equally present inside the said room or offices wherein PW1 and the accused person held their said meeting, and hence followed the aforesaid conversation as captured in the video clip marked exhibit number 5. Both the original and the translated transcripts of an audiovisual recorded conversation between PW1 and the accused of 4th January 2019 were also tendered in evidence by the prosecution exhibit P12A1B. As per the contents of the said transcripts, in particular, exhibit P12B, page 5, it was captured as follows. Kinyanjui. But, like what Kinyanjui? But 300,000 like this, my brother. You can't try and help me, my brother. Peter. Now, if we talk like that, I told them your son came and we talked and agreed on this. Kinyanjui. Peter. So we agreed we connect. Kinyanjui. There's no problem. I have not refused to give you 300,000 shillings. Going by the above quoted conversation, which in any way were not disputed at all by the accused person, as can be discerned from his own evidence tendered, it is patently clear therefore that the accused person must have had prior discussion over this matter with PW1's son, that's PW2. And in that discussion, the accused has settled for a financial advantage of 300,000, thus fortifying PW1 and two's mutual contention to that effect. This explains the reason as to why he confirmed to PW1 that they, that is, PW2 and himself, had talked over this matter and agreed on the said sum. Accordingly, therefore, he is confident that he neither demanded nor agreed to receive 300,000 from PW1, as corroborated by PW2, in my view, flies on the face of the above quoted conversations. My above finding is equally buttressed by further conversation between PW1 and the accused persons as captured in pages 6 and 7 of exhibit 12, as follows, and I quote again, Kinyanjui. Why are we not agreeing? Peter. I don't have a problem agreeing with you. Kinyanjui. I have brought you 100,000 shillings. Please agree to take. You know I am like your father. Peter. I must call them first. I can't make a decision on my own. Kinyanjui. Why call them? Can't you go and talk to them? Peter. You see they are people. I might do something. Kinyanjui. Peter. I do the upper we talk. Peter. I can't. It is better I call them we talk. Kinyanjui. Call them we talk. Peter. I call him so that I can tell him what we have said. Accused person did not request for financial advantage of 300,000 from PW1, as he would like this court to believe. Then why did he tell PW1 that he, the accused, had to call them, in quote, certainly his accomplices, first, since he could not make a decision on his own upon being offered 100,000 as part of the plan? That in case he did the opposite, in brackets, which according to me implies taking less amount than what had been agreed upon, then the rest, in bracket, his accomplices, would think that he had gone against them. Although the accused claimed that it was PW1 who said contention as holding no water on two fronts, not be constituted to have emanated from an innocent person who had resisted to be bribed in the manner the accused would like this court to believe. In fact, the converse is true, and I do find as much. In his written submissions, the defense counsel contended that the evidence taken by the prosecution in support of these two counts preferred against the accused person were not corroborated. Accordingly, he urged this court not to rely on such uncorroborated evidence as a basis of convicting the accused person. In support of this submission, he relied on the case law of Joshua Amakol v. Republic 2019 EKLR. Inasmuch as I do agree with the ratio designated in the above case law, I find that the same is not applicable to the instant case insofar as the second count preferred against the accused person is concerned. I say so because I have already found above that there was more than enough evidence which corroborated PW's contention that the accused had actually agreed to receive a financial advantage of cash 300,000 from him on 4th January 2019. That evidence came from PW2 and was further fortified by the accused aforesaid quoted and highlighted conversation between PW1 and the accused as captured in the transcript marked Exhibit P12B. The said conversations were neither disputed or challenged in any material respect by the defense counsel, as can be seen from the line of reasoning which he adopted of PW1, nor were the same controverted at all by the accused person in his own evidence standard. In the grounds, therefore, I find no plausible reason at all not to believe the same as the whole truth. Notwithstanding the foregoing, both PW1 and the accused in his own evidence standard. Again, I find no reason not to believe the same. Flowing from this uncontroverted and unchallenged evidence, it follows automatically that the accused had simply demanded 300,000 as a bribe, which in my view constituted an improper performance of his relevant assigned function or activity of meter reading. Therefore, said relevant function or activity in my view, and as ably proved by the evidence tendered by the prosecution witness herein, was improperly performed by the fact that the said water supply reconnection was made without PW1 being required to make any extra payments and or fines after another officer from the said department had gone to PW1's premises and confirmed that indeed he had not stolen any water. Although it was alleged that the accused person equally requested for a financial advantage of cashing $500,000 from PW2 on 3rd January 2019, as particularly in count number 1 herein, I am in concurrence with the defense counsel's submission that this count was not proved to the required standard. I say so based on the following reason. First, despite having been particular that the complainant with this count, despite having been particularized as the complainant with this count, PW2 confirmed and admitted that he personally never lodged any such complaint save for the one which was lodged by his father PW2, which only revolves around a sum of shillings 300,000. I therefore do not fathom as to how this complaint could be maintained without PW2 formally lodging any such complaint in the first instance. Secondly, the evidence by PW2 in support of this complaint, as rightly again submitted by the defense counsel, was equally not corroborated at all. That is, either by the video evidence and or the transcripts of the same tendered as exhibits herein. The furthest this matter went in this regard was a feeble and an inadmissible hearsay evidence tendered by PW1, in which he essentially and wholly relied on what PW2 had told him via cell phone as to how this offense was allegedly committed by the accused. That was not enough proof. On the whole, therefore, based on the reasons advanced, I do find and hold that the prosecutor failed to prove to the required standard the first count as preferred against the accused, and is acquitted of the same. On the contrary, I find that the prosecutor proved to the required standard the second count as preferred against the accused, and he is convicted accordingly of the same. So, can I get the records, previous records? Shillings 300,000 in default to serve 2 years imprisonment. You have 14 days right of appeal, certified copy.